Hi, and welcome to this latest immigration law update video. In this video, I wanted to look at Surinder Singh cases and the question of lawful residence. And I wanted to look at a case called Kutbuddin, and it's 2023 UKUT 76. Weird thing about this case is the decision was promulgated on the 22nd of March 2022 following a hearing in September 2021, but it wasn't reported as a reported decision until March 2023, a year later. But I've been reviewing some cases, some recent cases from 2023, and I thought this was worth a quick share and summarize on video. And I recently did a EUSS family permit appeal involving a Surinder Singh case. So a family member of a British citizen who'd been exercising treaty rights, free movement rights in the EU, and strengthened family life during that time. In this case, it was a mother, and they wanted to bring their mother back. That's the appeal that I recently did, and I relied on Kutbuddin in the appeal, which was successful. So it's a helpful case. The head note of the case, and I've shared my screen and I'll put the link to the judgment below this video, says this: the requirement that an extended family member must show prior lawful residence in another member state is not a requirement of EU law, nor is it endorsed by the CJEU. Now, in this case, which had been dismissed by the first tier tribunal, but is allowed by upper tribunal Judge Bruce, the Secretary of State had relied upon Regulation 91AB of the 2016 EEA regulations, and that's still relevant because they're cross-referred to by Appendix EU family permit. So these may come up in Appendix EU appeals. And that was the requirement that somebody be lawfully resident. In this case, it was an Ireland case. So the judge sets out the regulations, and you'll see in bold the extended family member was lawfully resident in the EA state referred to in paragraph 2A1. And the Secretary of State was arguing that lawfully resident means that they either had to have a residence permit, an EEA residence permit, or a right to remain under the domestic immigration rules of that member state, in this case, Ireland. What upper tribunal Judge Bruce does in this case is she goes back to the directive. She then looks at the case law of the CJEU, going back to Surinder Singh, the very helpful case of O and B. She looks at the case of Bangor, and she finds that there is no support for the Secretary of State's argument in the jurisprudence of the Court of Justice. So she then goes to look at a decision from the Court of Appeal, which the Secretary of State relied upon, and that is a case called Christie. It's a decision of Lord Justice Sales, as he then was. And if you look at paragraph 23, the reference is there: Secretary of State versus Natasha Ann Christie, 2018, EWCA Civ 2378. And she looks at the dicta of Lord Justice Sales in that case. But again, Upper Tribunal Judge Bruce rejects the Secretary of State's argument, and what she relies upon, and what I wanted to draw people's attention to, is the case of ZA. It's a reported decision from 2019, decision of Upper Tribunal Judge Rintoul. And there's a really helpful summary by Upper Tribunal Judge Bruce in paragraph 45. So she summarizes ZA. And in my recent Surinder Singh appeal, I relied on this paragraph. And if you're doing any Surinder Singh, say, appeal work, this is worth citing in your appeal skeleton argument. So Upper Tribunal Judge Bruce says this. In ZA, however, Upper Tribunal Judge Rintoul explains how the word genuine has a specific meaning in this context. The first tier tribunal had dismissed ZA's appeal, accepting the Secretary of State's case that bad faith was at play and that the family in question had only ever gone to Ireland in order to take advantage of the Surinder Singh route. Careful analysis of the jurisprudence in English and French led the Upper Tribunal to conclude that for the purpose of Regulation 9, motive is irrelevant. It did not matter on the facts of that case why the couple in question had chosen to go and live in Ireland. The only legitimate questions were whether they had in fact done so, whether the EEA national sponsor had exercised treaty rights while there, and whether family life had been created or strengthened during that period of residence. The term genuine is used by the CJEU simply in the sense that the exercise of treaty rights must have been real, substantive, or effective. Whether there was another ulterior or primary purpose is, absent abuse of rights or fraud, of no concern to decision makers. So then she goes on to say, paragraph 46, applying this definition to the scenario considered by Lord Justice Sales obiter dicta, it is difficult to see how the status of the non-EEA family member might impact upon whether the relevant residence is genuine or not. So on that basis, she finds, and for some reason, the reported decision, the numbering goes weird. So at paragraph 38, I think because she's quoted, the numbering has continued, so the formatting is messed up. But look at paragraph 38 at the end of the judgment. For those reasons, I must conclude that there is no basis in law for the conclusion reached by the respondent and the first-tier tribunal that these appellants are not eligible for residence cards simply because they failed to show they were, in inverted commas, lawfully resident for the entire time that they lived in Ireland with the sponsor. In treating the requirement in Regulation 9(1)AB of the 2016 regulations as determinative, the decision maker breached the appellant's rights under the EU treaties in respect to their residence in the United Kingdom, and she allows the appeal. So I hope that's helpful to you. That summary in paragraph 45, really neat summary, worth citing in appeal skeleton arguments and worth raising in any outstanding Surinder Singh work that you still have left. I hope that's helpful to you. Thanks for listening. Bye-bye.